Good morning, good afternoon, and good evening, depending on where you are. Thank you for joining Mayer Brown's Global Financial Markets teleconference series. Today's call is entitled, The Past is the Present, New York's Retroactive Foreclosure Legislation. My name is Krista Cooley, and I am a partner in the firm's Washington, D.C. office and a member of our Financial Services Regulatory and Enforcement Practice Group. I concentrate my practice on matters related to consumer and commercial financial products and services, and I had also advised clients on compliance with federal and state laws governing lending and servicing for financial institutions, mortgage lenders, consumer finance companies, and more. Before we begin, one or two housekeeping items. As regular listeners will know, this call is being recorded. We will email an audio link to all participants in case you wish to listen to the teleconference again or forward it to some of your colleagues. In addition, the recording will be available as a podcast. As we will not have a Q&A session at the end, please send any questions regarding today's topic by email to gfm@mayerbrown.com, and we will respond promptly to your questions. This email address can be found on your invitation as well. So joining me today is Mayer Brown partner Tom Panoff and one of our associates, Frank Doorley. Tom is a partner in Mayer Brown's Chicago office, and he's a member of our litigation and dispute resolution group. Tom focuses his practice on complex commercial litigation involving financial services and fintech companies, antitrust matters, and other high-stakes commercial cases. He practices before trial and appellate courts around the country and has litigated matters in over 30 states and approximately half of the 94 U.S. district courts. Frank is an associate in Mayer Brown's Washington, D.C. office, and like me, is a member of our Financial Services Regulatory and Enforcement Group. He handles a broad range of federal and state regulatory compliance matters, primarily for consumer and commercial financial product and service providers. And so with that brief introduction, we're going to begin today's discussion. So as we noted in our invitation to this call, it is not the easiest time to be in the mortgage business, as mortgage investors and servicers continue to deal with the fallout from the COVID-19 pandemic and its effects on borrowers, and rising interest rates are beginning to negatively impact the supply of refinance business from prior years and even deter some homebuyers who are seeking new financing. Most recently, the New York legislature has added another layer of complexity by passing a bill that would significantly impact the residential mortgage foreclosure process in New York if it's enacted. And it could potentially constrain lenders, servicers, and even investors' ability to efficiently prosecute foreclosure actions. So today, we're going to cover the details of that legislation, including the background in New York that led to its introduction. We're going to discuss the retroactivity provisions of the bill, which, if enacted as currently drafted, would apply, and also bring to your attention another piece of legislation in New York that, if it were to be enacted, could further impact the foreclosure process in that state. And with that, I will turn it over to Frank to get us started.
Thanks, Krista. I'm going to talk first about the first piece of legislation that Krista mentioned and the one that's attracting the most attention, and that is New York's so-called Foreclosure Abuse Prevention Act, or S5473. First, I'll give a brief overview of the background that led to the introduction and passage of S5473, and then I'll talk about the contents of the bill and the changes to New York law if it is in fact signed into law by the governor. To understand what led to the New York legislature passing this bill, it's helpful to take a step back for a quick overview of how foreclosure works. When a borrower accepts a typical residential mortgage loan, they sign a promissory note that contains a promise to pay the lender principal and interest payments on a periodic basis. If the borrower does not make their payments, then the borrower is typically in default according to the terms of most residential mortgage loans. Residential mortgage loans generally give the holder of the loan the authority to accelerate the unpaid balance of the loan if the borrower defaults. When a holder exercises that option to accelerate the loan, then all unpaid amounts on the loan become due and owing immediately. Accelerating a loan is also one of the first steps towards bringing a foreclosure action. Accelerating the loan allows the holder to bring a foreclosure action to recover the entire unpaid balance of the loan instead of having to bring an action only for the missed payments. Now, foreclosure actions are also usually governed by a statute of limitations that gives the holder a certain number of years to bring an action to enforce the entire amount of the debt before the claim becomes time barred by the statute of limitations. In New York, that statute of limitations to bring a foreclosure action is 6 years, and that 6-year statute of limitations begins to run when the holder accelerates the loan. While a lender's decision to accelerate a loan is not one to be taken lightly, it is also not necessarily permanent. A lender may subsequently revoke its decision to accelerate the loan. And once a loan is de-accelerated, it effectively returns the parties back to where they were prior to acceleration. And what that would involve is the holder generally reinstating the periodic payment schedule on the loan, and the borrower is once again responsible for making periodic payments, but the borrower no longer is required to pay the entire unpaid principal balance of the loan immediately. The ability to de-accelerate a loan can be beneficial for both the lender and the borrower. For example, a borrower and lender might be able to agree on a loss mitigation option during the pendency of a foreclosure case, and the lender can then de-accelerate the loan and give the borrower another chance to resolve the delinquency and stay in their home. Exactly how the holder of a residential mortgage loan can de-accelerate the loan in New York has largely been left to New York courts to decide, and it's typically been a fact-specific question. In 2021, the New York Court of Appeals, which is New York's highest court, addressed whether a holder voluntarily dismissing a pending foreclosure action was sufficient to de-accelerate a loan, and this was the Engel case. So just to give a very brief recitation of the facts in Engel, that case involved a loan that the lender had accelerated and commenced a foreclosure action in 2008. The lender then voluntarily withdrew the foreclosure action in January of 2013. In August of 2013, the lender sent a letter to the borrower informing the borrower of its intent to accelerate the loan, and the lender subsequently brought another foreclosure action in 2015 based on the second acceleration. The borrower answered the complaint and moved to dismiss the foreclosure complaint as time barred by the 6-year statute of limitations because, according to the borrower, the 6-year statute of limitations began running upon the first acceleration in 2008 and therefore expired before the lender initiated the 2015 foreclosure action. The trial court struck the borrower's statute of limitations defense and granted the lender's motion for summary judgment, but the appellate division reversed, holding that the acceleration was not revoked by the lender's voluntary dismissal of the foreclosure action. The New York Court of Appeals then granted review. The Court of Appeals held in Engel that the lender's voluntary dismissal of the first foreclosure action did constitute a revocation of the lender's decision to accelerate. The Court of Appeals agreed with the lender that the lender's voluntary dismissal of the first foreclosure suit constituted a revocation of the acceleration and therefore reset the statute of limitations to bring a suit on the entire debt. Because the lender's dismissal of the foreclosure action had restored the parties to where they were prior to acceleration, the court held that the lender only needed to bring the second foreclosure suit within 6 years of any subsequent acceleration, which the lender had. So currently, the state of the law in New York after the Engel decision is that voluntarily dismissing a foreclosure action is sufficient to de-accelerate the loan, restore the parties to their previous position, and effectively reset the statute of limitations to bring a foreclosure action. The Engel decision proved to be very controversial with some consumer advocacy groups who characterized it as providing mortgage holders a quote-unquote super right to reset the statute of limitations that was not available to other litigants. But it can be fairly difficult to get a state high court to overrule itself so quickly. So the New York legislature introduced S 5473 to effectively overturn the Court of Appeals ruling in the Engel case. Now I'll spend the next few minutes talking about what S 5473 would do if it is signed into law by the governor. First, the bill contains what is being called an anti-angle provision that would amend the New York civil practice law and rules to clarify that the voluntary dismissal of an action to foreclose does not toll, cancel, revive, or reset the statute of limitations applicable to that action. What this means is that a mortgagee would be time barred from foreclosing the mortgage after 6 years from the first date the lender accelerates the loan, even if the lender subsequently dismisses the foreclosure suit on its own accord. The second anti-angle provision in the bill amends the civil practice law and rules to provide that a mortgagee cannot unilaterally reset the statute of limitations in a foreclosure action once a cause of action has accrued. Under the bill, the only way for a mortgagee to extend the statute of limitations is by way of a written agreement with the borrower where the borrower agrees to the extension of the statute of limitations in a manner that complies with the New York General Obligations Law. A mortgagee can get a second bite at the apple in a subsequent foreclosure suit only if the first action was terminated for some reason other than a voluntary dismissal, lack of personal jurisdiction over the defendant, or for neglect or failure to comply with certain court rules or orders. And even then, only if the second action is commenced within 6 months of the prior case being terminated, and the new action is commenced within the statute of limitations that applied to the original action. S-5473 also affects what happens once a foreclosure action is barred by the statute of limitations. New York has a so-called election of remedies law that requires a mortgagee to either pursue the borrower in a foreclosure action and recover the debt through a foreclosure sale of the property, or to seek a money judgment on the promissory note, but not both at the same time. New York's appellate courts had recently held that because the election of remedies statute required a mortgagee to pick one or the other, the statute of limitations applicable to the remedy that the mortgagee did not elect to pursue first was tolled during the pendency of the first action. This allowed a mortgagee to recover a money judgment on the note later than 6 years after the mortgagee accelerated the loan and commenced a foreclosure action. S-5473 effectively overrules this holding as well. The bill provides that once a foreclosure action is barred by the statute of limitations, the mortgagee is prohibited from bringing any other action to recover the same part of the debt, which would include an action for a personal judgment on the note. So essentially, once the mortgagee exercises its right to accelerate, it has 6 years to complete its foreclosure action before it loses the right to recover the debt in a legal action. One interesting consequence of the legislation is that while consumer advocacy groups tend to be proponents of the legislation, the bill may actually have the opposite effect. When faced with a decision whether to bring a foreclosure action or to work with the borrower on a mutually agreeable loss mitigation option and dismiss the foreclosure, and potentially risk losing the ability to later foreclose if the borrower redefaults, lenders may be incentivized to proceed with foreclosure rather than to seek to engage with the borrower on a possible home retention option, if that is permissible under the applicable law. I'm now going to hand it over to Tom Panoff to talk about what is perhaps the most controversial feature of the bill, that it not only will become effective immediately when signed by the governor, but it will also retroactively apply to any pending foreclosure action in New York for which a final judgment and order of sale has not yet been enforced.
Thank you, Frank. Yes, as you were saying, the most controversial aspect of this bill likely is the fact that it would not only apply prospectively, but also retroactively to any foreclosure that has not yet taken effect. And I think broadly speaking, one could assume that there will be legal challenges on a constitutional level to that retroactivity provision. And there likely will be 3 categories of constitutional attacks that one could expect. The first is along the lines of a due process challenge. The second could be under the contracts clause. And then the third potential line of attack would be a regulatory takings argument under the takings clause. And I'd like to go through kind of each of those briefly and talk about some of the aspects of each potential line of attack. The first one would be, like I said, the due process challenge. Thankfully, there's a bit of a roadmap on that type of a challenge because the New York Court of Appeals in the Regina Metropolitan case in 2020 held that a recent act by the New York legislature, the Housing Stability and Tenant Protection Act of 2019, would violate the due process clause if it were to apply retroactively to certain overcharge cases that tenants would bring, in that it would change the statute of limitations from 4 years to 6 years. And in the Regina case, the New York Court of Appeals followed the Supreme Court's standard test for retroactivity to see if it would, 1, impair a party's rights that existed when they acted, 2, increase the liability for past conduct, or 3, impose duties for a completed transaction. Finding that those triggers did apply in the Regina case, the New York Court of Appeals then went on to hold that in order to satisfy due process, the law must have a legitimate legislative purpose furthered by rational means. The interesting aspect, though, I think, of the Regina case is that even though it articulated this rational basis type test, the court did go on a little bit further to ratchet it up and say that there's somewhat of a heightened standard requiring a persuasive reason for the potential harsh impacts of retroactivity. And the court went on to further note that when there's a contract or property right involved, that it requires even a stricter review by the court. And I think it's this latter point that you will see potentially with the new law that we've been discussing today, is that there will be a distinction by those who are challenging the act, if it does come into law, saying that you are challenging vested property or contractual rights that are in place here given the retroactivity provision. Whereas those who are defending the law will probably counter that by saying, no, you're just changing procedural rights that are in play here. Therefore, it shouldn't be given this closer look that the court applied in the Regina case. So I think that's a likely line of attack that we will see if this law is indeed challenged in court based on its retroactivity provisions. The second line of attack outside of the due process challenge is a lesser-known aspect of the Constitution, which is called the Contracts Clause, which is in Article 1, Section 10, Clause 1, which provides that no state shall pass a law impairing the obligations of contracts. And even though this is lesser known than the Due Process Clause, the Contracts Clause jurisprudence is very interesting in many respects. It should be noted that when the Constitution was first passed and enacted, that there was a very strict application of the Contracts Clause. Although, even though that was in place for the next 50, 60, or even 70 years, that jurisprudence started to subside a little bit, where the court became more deferential to the power of state legislatures and the government in terms of their police and regulatory power, and started to weaken the application of that clause a little bit. However, like all things, it started to shift back in the other direction. And in recent years, there's been a bit of a resurgence in the Contracts Clause jurisprudence. And I would like to point everyone's attention particularly to the Second Circuit's decision last year in the Melendez versus City of New York case, where the court did a very nice job of surveying some of the historical precedent and how the Contracts Clause has evolved over time. And in that case, the Second Circuit highlighted what the current test is for a Contracts Clause analysis. And they said that there are essentially three elements. The first one is there a substantial impairment of a vested contractual right? And then the second one, is it related to a significant and legitimate public purpose? And then 3, is it by reasonable and appropriate means? So similar to the Due Process Clause challenges that we talked about before, you see the similar kind of multi-part test that would be in play for a Contracts Clause violation. But you could easily see Contract Clause arguments being made here for this retroactivity challenge, because you have vested contracts that have been in place for some time that arguably the New York legislature is coming back and trying to change in a retroactive manner. The third potential line of attack that you could see on constitutional grounds is a takings clause argument, and this would be based on the subset of takings clause jurisprudence, which would be a regulatory taking. And I'm oversimplifying kind of in the interest of time here, but the essential inquiry here is that if a regulation or law goes too far, such that it unduly deprives a party of its economic interest, such that there is no longer any true economic interest in that right that did exist, that could constitute a regulatory taking by the government. And again, as you saw with the prior two lines of attack, it's traditionally a multi-factor analysis that has come into play where the economics of both legislation and of the proposed impairment are taken into accord by the court. And even though it is usually a multi-factor analysis, the court has struggled with time over time when it comes to applying this regulation and applying this type of analysis. And in many ways, it often falls back to Justice Holmes' old maxim here, which says, if the regulation goes too far, it will be recognized as a taking. So as one can imagine, there's obviously a lot of gray area when it comes to what is too far, but you could easily see arguments on both sides of that in any type of regulatory takings type argument that might exist here under the Act. So again, broadly speaking, there are likely or at least three lines of attack from a constitutional perspective that one could imagine being asserted here as to the regulatory aspects of this bill, but in particular into the retroactivity aspect of the bill, where it would go back and affect past foreclosures that were in place but not yet taken effect. So I think it will be a very lively area and one that everyone should keep their eyes on. It would be a very active area for the court. And given recent rulings by both the Second Circuit and the New York Court of Appeals, you could see a lot of interest in these areas and these lines of attack. Well, so with that, I'd like to turn it back to Krista now, who will talk about another aspect of pending legislation that's in place.
Thank you, Tom. So as you can see, based on what Tom and Frank have laid out, S5473 has understandably attracted significant attention from the mortgage industry, and for good reason. And as Tom said, definitely worth continuing to watch, both to see if it is finally enacted by the governor signing the bill into law, and then what happens next in connection with some potential court challenges that we expect may occur. So with that bill being out there, that's, like I said, it's gotten most of the attention, but as I noted at the beginning of our presentation, it is not the only piece of legislation that is pending in New York with the potential to significantly affect the mortgage industry related to foreclosures in that state. Specifically, on May 3rd of 2022, the New York Senate passed S2143, a bill which could, if enacted, dramatically expand the mortgage servicers and potentially the holders of mortgage loans liability to borrowers for violations of New York's mortgage servicing laws and regulations. And it could also further complicate foreclosure proceedings. So what this bill would do would be to amend the New York banking law to add two new sections to what is now Section 595-B, which applies to mortgage servicers. The first section that would be added by the legislation would grant borrowers a private right of action to enforce violations of New York's mortgage servicing laws and or the implementing regulations to those servicing laws. It would also allow the borrower to bring counterclaims or actions for injunctive relief for violations of those provisions of New York's banking law. So under S2143, borrowers would be able to recover statutory damages for such violations of $1,000 per violation. They would be able to recover their actual damages, which according to the legislation would be subject to trebling. And they would also be able to recover lawyers' fees and costs. Notably, the bill expressly states that both the mortgage servicer and the mortgagee are jointly and severally liable for any damages. And the term mortgagee is defined otherwise in New York's existing law that would apply to this provision to include both the owner or the assignee. The second addition to Section 595-B that would be implemented if 2143 were to pass in its current state would provide that compliance with New York mortgage servicing laws and regulation is a condition precedent to bringing a foreclosure action or any action for money judgment on the promissory note. So in addition to giving the borrower rights to a private right of action for violations of the New York servicing laws, it would also provide that the servicer could not foreclose until it met all of the mortgage servicing laws and regulations by making it a condition precedent to bringing a foreclosure action. So if enacted, the bill would allow the borrower to assert any noncompliance during the course of servicing of the borrower's loan as a defense to a foreclosure action or an action on the note. And so that's how it actually gets implemented, as by giving that borrower the right to raise these defenses in the foreclosure action. And the borrower could raise those defenses even if the servicing of the loan has been transferred to a different mortgage servicer when such action is commenced. Again, another very, very broad, small changes to an existing law would create very, very broad rights for the borrower and potential roadblocks to foreclosure for mortgage servicers, and have the potential to increase liability, not just for the servicer, but for the holder as well. Like the S5473 that we've talked about for the bulk of this presentation, this legislation S2143 would take effect immediately if it were enacted. Although S2143 does not contain an express retroactivity provision like those in S5473 that Tom just finished discussing. So the S2143 is currently pending before the New York State Assembly. So it would need to pass the Assembly and then be signed by the governor in order to become law. So that one's still a little bit of a different spot in the legislative process than S5473, but clearly merits close attention of the mortgage servicing industry as we work through these laws and the legislature in New York decides how they're going to work through them as well. So in closing, I want to say thank you to our audience for listening. We have a few brief reminders. You will receive an email with a link to the recording of today's call, and that recording will also be available as a podcast. And lastly, as I mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. We want to thank you again for your participation, and you may all now disconnect.